Well, welcome to this special live broadcast of California firearms law changes. Now, in just 2 weeks, some new firearms laws will take effect here in California that will impact both law enforcement and the general public. Joining me today is a panel of experts who will discuss these changes and answer questions that you may have. Let me introduce them now. With us this morning are Randy Rossi, Director of the California Department of Justice, Firearms Division, Dale Ferranto, Assistant Director of the Firearms Division, and Tim Rieger, Deputy Attorney General for the state of California. Thank you, gentlemen, for joining us. This is important for all officers to know. For our viewers now, you'll have the opportunity to call in and speak with these panelists or fax questions to the studio throughout the program. Now, the toll-free numbers to call are 800-265-5727 or 800-432-5727, and we'll show these numbers again in just a few moments. Going to cover at least 5 topics related to the firearms law changes that will take effect January 1st. Here they are. They include large capacity magazines, assault weapons, Senate Bill 15, unsafe handguns, Assembly Bill 491, carrying unregistered handguns, and gun shows. But first, let's get a general overview of the changes in law. Randy, what are some of the major pieces of firearms legislation that were signed last year by the governor?
You mentioned them, but I'd like to go over them in a little more detail.
Please do.
Yeah. The first bill, SB 23, that bill deals specifically with assault weapons and large capacity magazines. Another bill, SB 15, deals with unsafe handguns and requires testing of firearms before they can be sold, beginning January 1, 2001. Another bill you mentioned dealing with gun shows. It requires that gun show promoters be licensed, that gun show promoters follow certain regulated activities before they can conduct a gun show and during gun shows. It addresses vendors and things that may occur at that gun show are also controlled. AB 106, a safety device bill that requires before firearms can be sold, they must have a safety device attached to them or show proof that they purchased a safety device.
That's the child lock trigger, the trigger lock thing that we've all been talking about.
Yes, or gun safe.
Right.
And another, and probably the final major bill, is a bill AB 491. It addresses the long-standing anomaly in the law where under current law a person can be charged with a misdemeanor if they carry a loaded concealable firearm. This bill makes it a potential felony.
Dale, of these bills that Randy just mentioned, which one will have the most significant enforcement requirements for peace officers? Because they're the ones going to have to deal with this out there.
Sure. After reviewing all of these bills, we feel that SB 23, Senate Bill 23, the assault weapons law, is probably going to require the most knowledge and work with the law enforcement agencies. And that bill, just to re-mention, deals with large capacity magazines and also redefines characteristics for existing assault weapons.
Our first topic area here now is the large capacity magazines, because this has been an argument since almost time immemorial. Tim, how exactly in the law is a large capacity magazine defined? What is it?
That's a good question. The law specifically states that a large capacity magazine is any ammunition feeding device with a capacity to accept more than 10 rounds, but shall not be construed to include a feeding device that has been permanently altered so that it cannot accommodate more than 10 rounds, nor shall it include any .22 caliber tube feeding device.
That's interesting. Dale, what are some of the prohibitions relating to large capacity magazines?
Well, the prohibitions that are in the law are in regard to the sales of the magazines, the importation of large capacity magazines, the manufacture, transfer, giving, loaning, or purchasing of any large capacity magazine.
Well, Tim, obviously the next question is, does this mean that the actual possession of large capacity magazines is prohibited?
No, there's been some confusion on this issue.
A lot of confusion.
That's right. No, simple possession of a large capacity magazine is not a crime. Just the giving, lending, manufacturer, sales, the things that Dale mentioned, those are crimes. But simple possession is not.
So if you've got one,
you're fine. You're good to go.
It's legal.
Yes.
Okay. Randy, what about agency and peace officer exemptions for purchase of large capacity magazines?
The legislature specifically addressed agencies, both federal, state, and local law enforcement agencies. They're exempted, as are sworn peace officers. So that has been fully addressed.
So that's taken care of in the
Yes,
law.
they're exempted from the law.
Well, okay. Dale, what about retiring peace officers, retired or retiring peace officers?
Retiring peace officers can take with them large capacity magazines, possess them. They cannot thereafter, however, sell or transfer or purchase the large capacity magazines. So
In other words, you got it, you better keep it.
that's right.
Okay.
That
Go,
brings up
please.
a good point that
Yeah,
a
I
question
think
I've
it
had
does.
before.
Yeah, I think I know where you're going here.
If giving and lending are prohibited, what about between two peace officers? Is that a problem?
The giving or lending between two peace officers that are active on duty, sworn peace officers, is not a problem. That they can continue to do that. But if you're a retired officer, as the question you asked me,
Yeah.
then you're limited to what you've already taken from your retirement, the weapon and the magazines.
That makes some sense, I think, doesn't it?
Oh, absolutely.
Yeah, okay. Now, if you have questions about large capacity magazines, we'll take your calls or faxes right now. To speak directly to our panelists, call toll-free 800-265-5727 or fax your question to 800-432-5727. We can talk now about assault weapons. Randy, how does this new law impact the original Roberti-Roos Assault Weapons Control Act?
The original Roberti-Roos Assault Weapon Control Act addressed assault weapons by make and model. What happened, some enterprising companies took advantage of the law and developed weapons that were outside of those specifically listed.
Sometimes just barely outside.
Just barely, and
Yeah.
in the case of Intertech DC-9, the DC stood for District of Columbia, which also had a Roberti-Roos type ban. So rather than go down that path, and in that our law was and is being challenged as to our ability to add weapons to that list, the legislatures chose to address that by characteristics. And so the Roberti-Roos law still stands. Those registrations are in place. They do not go away. And people who have those weapons had to have registered them within that registration period. These new weapons are by characteristic, and that registration period kicks in January 1.
Well, Dale, that brings up the obvious question. What are the defining assault weapon characteristics?
This is the most, if you will, controversial and also detailed part of the law.
And the one that most officers in the field are going to have to make judgments on.
That's
yeah.
correct. For the officer on the street, this is probably the most important aspect of the assault weapons law. Basically, there are 8 sub-elements to the characterization of the weapons, and I'd like to go through those slowly with you.
Yeah.
The first overriding and defining of an assault weapon is this by law: a semi-automatic center-fire rifle that has the capacity to accept a detachable magazine and any one of the following characteristics. We've brought along a weapon today to help be able to explain and show this in a visual sense.
Which all us military veterans will recognize as something very like the AR-15.
Yes, this is a match target Colt 223. And the first characteristic that has become of controversy and discussion is what the law defines as a conspicuously protruding pistol grip. And what we are doing right now are drafting regulations to help intensify the intent of the legislature to show what that means. Our current drafts reflect this type of a definition, that if you were to draw a line from the barrel parallel to the barrel and pass it through the exposed top of the trigger, that whatever fell below that, if it was capable of being handled with one hand and accurately yielding the weapon, then that would be within the law and defined as a conspicuously protruding pistol grip. That's currently in draft regulations, and that's where we think we'll take it to for public comment next month.
Okay.
The second characteristic is a thumb hole stock. It's a type of stock that would allow for a grip of the weapon, again with one hand, and the ability to be able to fire the weapon accurately using just one hand. Next is a folding or a telescoping stock. That is another one of those elements that would make the weapon prohibitive. Or a grenade launcher or a flare launcher on the end of the weapon. Finally, a flash suppressor.
How weird is that we have to put a grenade launcher in there? I mean,
Well, some weapons have the ability to actually launch a flare or a grenade, although it wouldn't be normally done. They do have that capability, and so that's why the law has been added to define that.
cover it if you have to. Yeah.
Yes, sir.
And actually, interestingly, ATF, the federal folks, say that the flash suppressor on the AR-15 or the M16 was actually designed to launch a grenade off of.
It was, yeah.
Yeah, so they consider that not only a flash suppressor, but a grenade launcher as well. So under federal law, it's kind of an interesting expansion of the definition.
But I would think a necessary expansion.
In this context, yes.
Yeah, good.
Going on, the flash suppressor, as already mentioned by Tim, is another one of these elements, and that includes the devices that are called flash hiders, but it does not include devices like compensators and muzzle brakes.
Right.
So for people who understand the weaponry and the terminology, they'll know what I'm talking about. Flash suppressors and flash hiders are covered by this law. Next is a forward pistol grip, the kind of grip that is usually ahead of the trigger group and allows for the control of the weapon in a sort of a machine gun fashion, if you will.
Right.
And those are basically the internal elements of defining the characteristics of an assault rifle. Then the second type of assault weapon is defined as a semi-automatic center fire rifle that has a fixed magazine. So that's the differentiation, a fixed magazine with the capacity to accept more than 10 rounds. So again, we're getting back into the large capacity magazine on an assault rifle, but in this case it's a fixed magazine to the weapon. The third type would be a semi-automatic center fire rifle that has an overall length of less than 30 inches. The fourth type is a semi-automatic pistol. We've now moved from a rifle definition to a handgun definition that has the capacity to accept a detachable magazine and any one of the following characteristics: a threaded barrel capable of accepting a flash suppressor, a forward hand grip, or a silencer, a second hand grip on that pistol, a shroud that is attached to or partially completely encircles the barrel that allows the shooter not to be burned by the barrel, and the capacity of one of these pistols to accept a detachable magazine at some location that is outside of the pistol grip.
So these are your Uzis, your Tech-9s, your Mac-10s, your what we would think of, we always see in the movies as the machine pistols.
Yes.
For want of a better term.
Now brings those under the purview of the law. The fifth type is a semi-automatic pistol with a fixed magazine, similar to the definition from the rifle, from a detachable to a fixed magazine. So a semi-automatic pistol with a fixed magazine that has the capacity to accept more than 10 rounds. Again, another large capacity magazine. The sixth type is a semi-automatic shotgun that has both of the following, and I emphasize both. You have to have both of these elements: a folding or a telescoping stock, and a pistol grip that protrudes conspicuously beneath the action of the weapon, or a thumb hole stock or a vertical hand grip. So the same definitions that we just characterized on the rifle we showed would apply to a shotgun.
Is this oriented toward the type of things that law enforcement sometimes has come to call the street sweeper?
Yes. Yes, exactly.
Those are falling into, yeah, well, all these things are falling into the wrong hands. These laws wouldn't be here in the first place.
That's correct. The assault weapons then talk about shotguns in two other senses. One that is a shotgun that has a detachable magazine, and these are fairly rare. You don't see many of these. And the final element or the eighth element of the assault weapon definition is any shotgun that has a revolving cylinder. And again, these are not common items that we see on the street.
But we could see more of them.
Yes, sir.
Yeah. Randy, is DOJ developing regulations to help implement this law?
Yes, we are, and this is not something that's foreign to legislation. It's often the case where legislative committees can't get into the specifics of legislation. Instead, they turn to the regulatory process. Our goal in looking at this law was to take something that is subjective, a conspicuously protruding pistol grip, and make it objective. Make it so that an officer can take the weapon, look at it, draw this imaginary line through the top of the trigger opening, and see whether or not there's a grip, for instance, that someone can grasp, control, and fire the weapon with. To look at the various issues and to help us with the regulations, we convened a group of stakeholders, people who have a tremendous interest in this, to help us identify those areas where we need to focus in the area of regulations and also training. In fact, this telecourse came out of that group. We had the National Rifle Association, California Rifle and Pistol, California Gun Owners Association, firearm dealers, PORAC, CPOA, Cal Chiefs, the District Attorney's Office, a member of the public, and others sitting down at the table, looking at this law, helping us to identify those areas that may need further clarification. We had those meetings in October and November. It's with that information that we drafted the regulations. Those regulations have been drafted. They're just about ready to be released. We hope to release them next week to those stakeholders, to law enforcement, to those associations, but those regulations will be in draft form.
So you're, in a sense, looking for public comment in a way.
Yes, and it's about a 6-month process,
Yeah.
and that's as fast as the law allows us to do it in this situation. So we will take those regulations, we'll have public hearings, public comment. It's important to stress that those are draft regulations. They don't have the power of law. But over time, after we have those hearings, after they go through the process, they will. Okay. But in that the law kicks in January 1, it's important that the stakeholders understand at least what our intention or our interpretation of the intent of the legislation is. And so we were careful in drafting those regulations.
Okay, we have a caller. David Knight, LA Port Police. David, what's your question? Who's it for?
I have a question for anybody who cares to answer. It's about retired police officers. And you said before that they could keep the high-capacity magazines they had at the time of retirement. Was that only for a duty weapon, or is that all weapons they happen to have at that time?
Yeah, that's a good question.
Actually, I think a logical interpretation of the law would have to be that it would be for your duty weapon. And this brings us to the next question that's coming up, and that has to do with registration of assault weapons and high-capacity magazines and so forth. You wouldn't be able to purchase them after you're retired, which you would while you're active or a sworn peace officer. So I think you're limited just to your duty weapon, I would think.
Although I'm not so sure I understood the question. If he's referring to magazines, then clearly the law does not address possession.
Correct.
You can continue to possess those magazines. It's just as far as acquiring additional magazines, if it's not assault weapons. If it's talking about
David, let me ask you: was that pretty much the intent of your question?
What I was thinking of is I have several weapons with high-capacity magazines, and they're not all city issued. Would they be grandfathered in as well for retired police officers?
Yes, exactly. The simple possession of any high-capacity magazine is not against the law.
Well, how about the use of them?
That's not covered either. It's only the giving, lending, manufacture, transportation, sale. So you couldn't give those to your friend. You couldn't even loan them to him on the range.
I understand that. What about how assault weapon registration for retired police officers? Would they be required to register the weapons they already had?
Yes, that's correct. In fact, under the new law, all individuals, any privately owned assault weapon has to be registered. There is no exemption for an individual law enforcement officer. Agencies are exempted, and agency-owned weapons are exempted, but not individually owned peace officer weapons.
So if they have a assault weapon, they can take it to the range and shoot it legally, no problem?
If it's registered.
If
Yes.
it's registered?
Yes, if it's registered.
It's registered then.
That's correct.
Okay, that's all I have.
Hey, well, thank you very much for calling, David. I'm glad we could answer your question.
Okay, thank you very much.
Randy, let me ask you, can an assault weapon be kept without registering it if the offending part is removed?
Setting aside the Roberti Roos weapons, those weapons had to be registered within that time period. If they own them, possess them now, and they're not registered, they're in violation of law, whether they're a member of the public or law enforcement. But turning specifically at SB 23 that defines assault weapons by characteristics, if you take off an offending part, an offending characteristic, then it no longer meets the definition of assault weapon.
Yeah, how would you do that with the with our friendly
Looking at this weapon, if somebody, the offending characteristic on this weapon is a conspicuously protruding pistol grip.
Sure.
If somebody unscrewed this and took this off, this would no longer have that offending characteristic, that ability to grasp, control, and fire.
It would also be really, really hard to shoot.
Unless it was from the shoulder.
Yeah.
So if somebody takes this off, they take away the offending characteristic, it becomes a lawful weapon, not in need of registration. Similar to nunchucks, if somebody takes the chain away from the two sticks and it becomes a chain and two sticks sitting on a car seat, not assembled, you don't have a problem.
Well, it seems like we're just asking for loopholes here, aren't we?
Actually, that's a good point. I've had, as you can well imagine, we've had many calls and letters.
And you'll have many more, oh boy.
And one of the biggest concerns is the initial definition of the initial definition of an assault rifle or an assault pistol. And the first element is that it be semi-automatic for a rifle, centerfire rifle that has the capacity to accept a detachable magazine and any of the following. Many people have interpreted that to mean the capacity to accept a detachable magazine and the capacity to accept any of the following. So we're getting questions like, well, if I still have the mount for my pistol grip, or I still have the mount for my flash suppressor, or any of those characteristics where it has a capacity to accept, is that what the law means? And I think a plain reading, common English plain meaning, is that it has to have the particularly named items already on the weapon in order to be an assault rifle.
As long as we got you, Tim, what assault weapon activities are controlled by the law?
That's a good question, and actually all lawful assault weapon activities are specifically enumerated by law, okay? And the first requirement is that the weapons be registered. And I wanted to just touch on this real quickly because this is also a common question.
That's the baseline.
The baseline is it has to be registered.
Yeah.
And to register a weapon, you can go to the dealers, the sheriffs, the police. You can call or write to us directly. We will have a website at www.regigun, which is regagun.com. And you'll be able to pull that right off the line. Once it's registered, and again, like I said, all privately owned assault weapons must be registered. Then, once you've accomplished that, unless you have a specific use permit from the Department of Justice, you're limited to the following. And that sounds draconian. You're limited. You can only do what's allowed by law. But it's actually not much different than any other weapons usage. And just so that it's crystal clear and we're precise, I'm just going to read to you what those things are. First of all, a properly registered assault weapon can be possessed at a person's residence, place of business, or other property owned by that person, or on property owned by another person with that owner's express permission. So you could take your rifle next door to your neighbor's house because he wants to see it and show it to him. That's not a problem. So
a question immediately pops into my mind when you say other property owned by that person. Does that include a car?
Yes, and actually the transportation of assault weapons is the same as for a concealable weapon. And there's new law dealing with the transportation of obviously concealed weapons and ammunition, but assault weapons have to be either locked in the trunk or in a lockbox in the interior of the car, just like a pistol, revolver, or other concealable weapon. It's a good question. Yeah. Or you can have an assault weapon on the premises of a target range of a public or private club or organization organized for the purpose of practicing shooting targets. You can also have an assault weapon on a target range that holds a regulatory or business license for the purpose of shooting at that range. You can also have your assault weapons on the premises of a shooting club, which is licensed by Fish and Game, by the Department of Fish and Game under the Fish and Game Code. You can have assault weapons while attending any exhibition, display, or educational project which is about firearms and which is approved by law enforcement either locally or nationally, or a state-recognized entity that fosters the proficiency in or promotes education about firearms. Very similar to any other lawful use. Finally, you can have an assault weapon on publicly owned land if the possession and use of the firearm is specifically permitted by the managing agency of the land. So if BLM says, yes, we'll give you a permit to shoot your assault rifle on BLM land out at your privately owned, well, at some public land,
wherever,
that's fine. Sure, any place, you bet. And again, you asked the good question, which was, when you're transporting it, what do you have to do? And obviously, as I said, it's the same as a concealable weapon. So it's got to be locked in your trunk or in a lockbox.
Well, those are strict, but they're not exactly what I call draconian. Randy, is there a law enforcement agency exemption for assault weapons?
There is. It's more narrow than large capacity magazines. Large capacity magazine, it's any federal, state, city and county, or county, a law enforcement agency. In the case of assault weapons, it's more limited to Department of Justice, counties, cities, and a few other agencies. So this is one area where departments may want to look at the law to make sure that they are exempted from the assault weapon legislation.
Tim, you might want to just touch again briefly. We've talked about this peace officer exemption for assault weapons.
Yes, and what I want to say here is, first of all, there's no individual exemption for peace officers. But we're getting a lot of questions from police departments, the chiefs, captains in charge of, the Millbrae Police Department that deals with the San Francisco International Airport and so forth. Everyone's asking, well, what about the situation where a privately owned rifle is my duty weapon? And several of the agencies have that set up, including the federal government. The FBI does that. They buy their own rifle, they send it to Quantico, it's approved, test fired, and they have a letter that says this rifle's approved. What you'll have in California after the first of the year are two distinct groups of peace officers. Those officers who privately own their rifle as a duty weapon will have to register that weapon and still use it in their duty capacity. Those officers hired or who move into a category where they use rifles in their performance of their duty will have to use an agency weapon. They won't be able to purchase these assault rifles for themselves for agency use. So you'll have these two distinct groups.
Sounds like that's addressed toward people like SWAT snipers and things like that.
Absolutely. And I do want to point out one thing. The law is crystal clear that the possession of an assault rifle or an assault weapon by a peace officer is authorized whether or not on duty, as long as that rifle is being used for a law enforcement purpose. So, for example, it would be perfectly permissible to take your agency weapon, keep your agency weapon with you in the trunk of your car, which is common practice for a SWAT team member.
Sure.
Or any other peace officer authorized to use the assault rifles. They can keep it in the trunk of their car. They can take it out to go to the range because that's a lawful law enforcement purpose. Proficiency with a weapon is, of course, an essential element of being a good officer. But you couldn't go hunting with it. You couldn't go hunting with an agency weapon. So that's the distinction. So all those officers who are now using their own privately owned, purchased weapons as their duty weapon will have to register them.
Dale, what about the retiring peace officers?
We sort of answered this question with the caller that called in, but retiring peace officers can possess the assault weapon as long as it's then registered to them personally when they retire.
For me. Randy, how will the public learn about this new law? Because obviously they're going to need to know about it.
That's something that came out of the stakeholder meeting, that there needs to be education and training to the public, to law enforcement. We're addressing that on a number of different fronts. With firearm dealers, we've already produced, and they're in the process of being distributed, posters that provide information on this, flyers that will be available at gun dealers. We're providing information to law enforcement. We've been to, or will be to, 13 locations plus this to get the word out to law enforcement so that they can then pass out that information. We have a website that Tim mentioned, the Rieger website. We will have an 800 line, which will be a 1-800, or I think it's 888 Rieger. It could be 1-800, excuse me, 1-887, I believe it is, Rieger. But we'll get that out. That'll be on the posters. And finally, we'll have a multimedia campaign, radio, TV, public service announcements, paid public service announcements, where we will be getting the information out to the public using.
So you're going to make a real public awareness campaign out of this.
Absolutely.
Which, I think that you have to do that. Tim, what about assault? Now, can assault weapons be inherited? Can they be passed down father to son?
No. The law is very clear on this. It's in Penal Code Section 12,285, Subdivision B, for those who want to look it up. The way the law works is that if you inherit or come into possession of assault weapons by intestate succession, you have 90 days to either sell it to a licensed firearms dealer, transport it out of the state, render it inoperable, or turn it into law enforcement. Now, rendering inoperable, that's a question we get a lot of times. What does that mean exactly? Most of the experts will tell you if you cut the receiver open so that it can't fire,
Right.
if you weld the barrel shut, of course that gets tricky because you can swap the barrels out.
Oh, easy.
You know, there's a
Yeah.
lot of those kinds of things. But if you're in possession of one of these and it's not, and you're not the lawful registered owner, you better not be able to fire it. And then finally, if you go past that 90-day period, the only available remedy after that is to turn the weapon into a sheriff's or police department, excuse me, or police department, and you should call them, notify them ahead of time. that
Yeah,
you're
not a
coming
real
in.
good idea to walk into the front desk
Yeah.
with an AR-15 and say, "Hi, I want to turn this in."
No.
We've all seen people, you know, America's dumbest cops and things do that. What about kids, people under the age of 18? Is it legal for someone under the age of 18 to register or possess an assault weapon?
No, neither. They can neither possess nor own an assault rifle, although if you're 18 or older, and this is important with respect to both the question just asked and the former question, if you are in the same family and live in the same household or in the same residence, you can co-register assault weapons. So, for example, as long as your son or daughter who's over 18 lives with you, you can co-register the weapon.
But not if he or she is under 18.
No.
Okay. Now, if you have questions about the assault weapons law, we'll take your calls and faxes right now. To speak directly to our panelists, call toll-free 800-265-5727 or fax your questions to 800-432-5727. You know, we've talked a lot about the new assault weapon law, and I'm sure we'll get a lot of questions about the subject. Now let's talk about Senate Bill 15, the unsafe handgun bill. Randy, specifically, what does that legislation do?
There was a concerted effort on the part of the legislature to deal with weapons that may not meet people's expectations as far as safety if they're dropped, perhaps accidentally discharging, not being able to function after X number of rounds are fired through the weapon. That concern was addressed by SB 15 that requires the safety testing and the functional testing of handguns before they can be sold.
Pretty much, this is Saturday night specials and things we're talking about, basically.
Yes, but all firearms will have to undergo this test. It's a drop test, it's a firing test, and that law will kick in January 1, 2001. Those weapons to be sold by dealers have to be on a roster, and we're required to identify independent laboratories that will be conducting that test.
Well, that's good. Dale, how does this legislation treat revolvers as compared with automatic handguns?
There's just a couple of details that enhance the law to differentiate between the revolver and the pistol. First of all, both have to meet the standards of a 600 round plus test under certain conditions and circumstances that the laboratories will design, and then they have to all meet some type of a drop test from about a 3-foot level at different angles. The revolver itself, however, specifically in the law, must have a safety device that causes the hammer to retract to a point where the firing pin does not rest upon the primer of the live cartridge. So that's a very specific element. And with the pistol, it must have a positive manually operated safety device, and this standard has already been determined by the Bureau of Alcohol, Tobacco, and Firearms that we will follow. Both, however, must meet the standards of firing the weapon, so many rounds through the barrel, and then the drop tests. And I think Randy has a little bit more information on the positive manually operated safety definition.
Yeah.
This was quite an issue before the legislature.
I'll
What is a
bet.
positive manually operated safety? Actually, the 1968 Federal Gun Control Act requires that all firearms imported into the United States must meet this. So BATF looks at the weapons and ensures that they meet that positive manually operated safety requirement. So all imported firearms, be they Glock or any other manufacturer, since 1968 had to pass that test. There was some controversy as to whether or not those weapons would pass. They had to pass or they couldn't be imported. For domestically manufactured weapons that don't have to meet that standard, we will, through our testing, determine that they meet the same characteristics as those weapons that have these features. And if they do, we will deem them to meet the positive manually operated safety requirement.
And that seems to make sense. Dale, once again, we keep coming back to this question: are police officers exempted?
Yes, peace officers are exempted from this requirement. And I was asked an interesting question the other day during a presentation of these laws about an agency, which Tim will answer here in a minute about the exemptions there. But the question came up, will our agency be required now to provide us or replace for us weapons that we currently carry that may not meet this law? They were concerned about, obviously, the safety of the weapon as well as the economics of replacing hundreds or possibly thousands of guns.
Yeah.
Right.
What about the agency exemption, Tim?
They're exempt as well. In fact, a good way to think of all of this, and the way we kind of remember it, is that with respect to these new laws, law enforcement agencies are generally exempt except for the assault weapons provisions. So high-capacity magazines, drop testing, safe guns do not apply to law enforcement. Basically, only the assault weapons provisions do.
This is pretty much active duty.
Yes, that's correct.
Yeah, we probably need to make that distinction because we've already proven there's going to be some distinction between active duty and retired or retiring.
Sure.
Randy, what about private party transactions?
Private party transactions, those transactions between police officers, that's required by law, that will go through a dealer, or from one private individual to another private individual. In the SB 15 unsafe handgun area, they're exempted. The purpose behind this law is to stop the introduction of new weapons by dealers or used weapons by dealers into the community. So that's where the stop will occur. Private party transfers are exempted from this law.
You know, it strikes me that there shouldn't be a lot of backlash about something like this among law enforcement, because if anyone understands the need to have good, safeable weapons, it would be law enforcement.
And we've had, in some of our agencies nearby, situations where officers have dropped a weapon, accidentally discharged, and didn't know that the firearm had that capability.
What about possession?
Possession isn't addressed. This only deals with the transfers by dealers.
I think possession will be addressed somewhere down the line.
Don't know.
This has got to, all of this is going to be just, it strikes me as a constantly evolving body of law. Like every time there's a legislature in session, there's going to be something else.
Well, there were 30 bills introduced last year. Probably 10 or so made it out. These are some of the more substantive bills that made it out. We understand there will be a number of bills introduced this year as well.
And you folks are the ones who have to keep up with this. Boy, isn't that fun. Now let's go over Assembly Bill 491, the loaded and concealable handgun legislation. Randy, what's the background of this legislation?
This has been a piece of legislation that's been pending before the legislature for years. This was sponsored by the California Police Chiefs Association to address a situation that exists under current law where a person can carry a dirk or dagger and be subjected to a felony, potential felony, where a loaded concealable firearm is a misdemeanor. This piece of legislation says beginning January 1, 2000, if somebody carries a loaded concealable weapon that is unregistered, then they would be subjected to a potential felony.
Tim, what exactly does this legislation do? I mean, operatively, what happens here?
Well, as Randy said, it increases the penalty for someone who's in possession of a pistol, revolver, or concealable firearm that is not registered to them. So it raises the penalty from a misdemeanor to a wobbler, exposure to a potential felony, as Randy said. And what the statute says is that, or what it does, is it applies when the handgun and unexpended ammunition for that handgun are either in the immediate possession or readily accessible to a person who is not listed with the Department of Justice as the registered owner of that gun. And that's the modification to Penal Code Section 12,025. The law also modifies Penal Code Section 12,031 and amends it to add, and it applies when the loaded handgun is in the immediate possession of a person who is not listed with the Department of Justice as the registered owner of that handgun.
Well, Dale, how can a person determine if his concealable firearms are registered with DOJ?
Any person can can write to us with a notarized letter describing the weapon, describing what they have in their possession, and we will check the system to see if it is registered.
Let's suppose it isn't, Tim. Can a person register an unregistered concealable firearm with DOJ?
Certainly, and they can get those forms again, as we said. The dealers, sheriffs, police, call us directly, write to us directly. Certainly, certainly. That's being encouraged by the law.
Okay, now if you have questions about Senate Bill 15 or Assembly Bill 491, we'll take your calls or faxes right now. Once again, to speak directly to our panelists, call toll-free 800-265-5727 or fax your question to 800-432-5727. You know, guns have received an awful lot of media attention lately. Randy, what's the driving force behind the new gun show legislation?
Following the Columbine shooting and some arrests that occurred surrounding the Pomona gun show, the legislature wanted to take action in this area. This is an area where actually the industry came to law enforcement and really took a preemptive strike, said that this is an area that they would like to address. They would like to work with us to more tightly regulate the activities, to demonstrate that they are handling shows in a responsible manner. What came out of that is the language in 295, a joint project between the gun show, a producer, industry, and law enforcement. It covers a wide variety of aspects surrounding gun shows.
Dale, what are some of the specifics?
There's a number of specifics in it, but I'd like to also reemphasize that the spirit of cooperation that exists between the law enforcement authorities, DOJ, and the promoters and the facility managers has been very good. And I would encourage any law enforcement agency that deals with gun show promoters or facilities to continue in that spirit to make sure that the law is fully understood and implemented. First of all, the requirements are on both the promoter, the facility manager, and the vendors that come to these gun shows. They have to have knowledge of the law. They have to express a knowledge of these statutes. They have to have a insurance policy of $1 million that ensures liability at the show. We do checks on the vendors and the sellers of the guns to make sure that they are licensed and in good standing. There's requirements on signs that have to be posted, either restricting who can enter the gun show and where gun sales can occur and under what conditions they can occur. They also have to keep records, and these records are subject to inspection both during the gun show as well as 2 weeks after the gun show by law enforcement authorities. There's security issues regarding who's there that will provide the security, whether they be sworn or private enterprise, and Tim will address that in a second. Employee IDs are required and vendor IDs so that law enforcement can see who's working behind the counters. The events list must be published, an annual list to show where the shows are, when they're being held, and any changes to those annual lists need to be sent to law enforcement. Carrying concealed weapons at the gun show is fully restricted to peace officers, sworn peace officers, and the security personnel that are employed there. And there's also another phrase within the law that says that no activities that incite or encourage hate crimes will be permitted at these gun shows. Finally, no black powder is allowed to be there because of the fire and explosive danger, and also all ammunition must be in containers.
Now, Tim, you say that law enforcement has to review the safety plans. What are law enforcement responsibilities relative to these safety plans, and what happens if a law enforcement agency determines that a safety plan is not satisfactory, that they're not following the letter of the law?
That's a good question, and it's a very tough question.
That's why I asked it.
Law enforcement's responsibility is to review the plan. The approval authority, however, under the statute is the facility. So if law enforcement has a concern about let's say the adequacy of the security personnel, again, re-emphasizing what both Randy and Dale said, they should go back and cooperate with the producer and the facilities managers and try to negotiate a resolution. Barring that, however, there is not authority for them to say shut the show down. And the reason that this is an important question, recently the Pomona Gun Show ran into some difficulties with the Los Angeles Council, and as you probably are well aware, the federal court said, hey, this is a contractual issue. Sure, it has public safety overtones, but there's already an existing contract.
Yeah.
You can't shut that down. if when the time comes to renegotiate the contract, that's an issue for your city council, your county council, your city attorney, your county council, meaning the lawyers, the attorneys. Right. So other than looking at it, expressing your concerns, communicating that, keeping good records of that, your options are to go to your council.
Doesn't that strike somebody as a major league loophole? I mean, is this something that needs to be addressed?
This was actually the subject of a lot of conversation as a legislation.
I can't imagine why.
The police chiefs didn't want to be in a situation where they had the responsibility of approving the plan. They felt that the facility manager, who is often might be an agricultural affair, not a local jurisdiction venue at all, that they should ultimately be in the position of approving or disapproving what meets their needs and what they have experienced in the past, not some outside law enforcement agency. This was a request by law enforcement, accommodated by the gun show industry, agreed to by the facility managers. So there was a lot of thought that went into this.
Okay, it just strikes me that I feel like there's going to be a problem arise out of this somewhere down the line, and I can't really articulate what it is. It just seems like there is, but we'll see what happens. Okay, now is your chance to call in. If you have questions about gun shows and the new laws, we'll take your calls or faxes right now. Again, call us toll-free 800-265-5727 to speak directly to our panelists here, or fax your question to 800-432-5727. It is very, very, very interesting to think about. Because I keep thinking about this, and as I read the wires and I read the news and everything like that, I keep hearing this kind of thing coming out of our legislature, and then I hear all this yelling and screaming about laws in Congress. And what pops into my head is the idea of federal preemption. Tim?
Sure, that's true.
And I wonder down the road if this is going to fall to the whims and vagaries of federal politics.
Well, I think that that's certainly a concern of a lot of people. But you make a good point, and particularly for the peace officers here in the state of California. Federal law sets the floor for what is or is not permissible. And then the state laws, in this instance, are more restrictive. So as far as the federal baseline, that's already in place and has been for almost 30 years. So what we're really talking about are new additions that are more restrictive under state law. Although interestingly, one of the terms that's caused a lot of emotional outpouring, to put it nicely, is this conspicuously protruding pistol grip. Mm-hmm. And everybody says, oh, what the heck does that mean? That's vague, it's ambiguous. It's interesting to note that definition is taken directly from federal law. That's out of Title 18, and Senator Parada's office took that term and stuck it in, and it's been the subject of much litigation and has been found to be constitutionally sound, at least with respect to vagueness and some of the other challenges. So I think what you're going to find is that there is an interplay between these laws. The standards, say, for what constitutes a flash suppressor would also be something that we would maybe turn to federal law on.
Also, Doug, if I might, there was a lot of thought that went into these bills, and as they were drafted, we looked at the experience of other states. And California has a long history in the area of law enforcement and gun regulations of having some of the more advanced or restrictive laws. I'm sure that over time some of these laws may spread, or some states may learn that some of our efforts need to be improved upon, or we may have to go back to the legislature. A key point here, though, is that as these laws become more and more difficult, more and more challenging just because of numbers, like traffic laws where you have motor officers, or narcotic laws where you have narcotic officers, we're now to a point where it probably pays to have somebody on your department that has some expertise, so that they can help the officer make the determination as to whether or not a weapon is prohibited or is okay. Now, what we try to do in our goal was to, through regulations, take something that, although legally sufficient as demonstrated by case law, let's improve upon that and make that something objective versus subjective. And if I may, I'd like to clear up two things.
Please do.
Our website and 800 number. The 800 number and website will be operational January 1, 2000. The toll-free 800 number is 1887 Regagun, Regagun. The website address is www.regagun.org.
Thank you.
So I hope that's helpful.
Got that. Okay. And I'm sure everybody got all that written down, right? I call him. Dale, can jurisdictions, and I think we've had this, we touched on this briefly with Tim, but can jurisdictions now opt to not allow gun shows? Can the LA County Board of Supervisors or the San Diego County Board or whoever say, no, we're not going to have any gun shows in this county?
Yes,
at least not on land that we control.
Yeah, it appears that, as Tim mentioned, contractually they have that right. There has recently been some lawsuit actions with the Pomona Gun Show that were in the federal court system, but the local jurisdictions do have the right to not allow these to be held.
Tim, would that be only on, for example, LA County said, no, you can't have a gun show here on the fairgrounds?
Sure. That's correct. Absent an ordinance or a regulation promulgated through the legislative process or through the council, that would be correct. It would just govern public land. Of course, in this modern day and age, most of these large forums are public land. So,
yeah, they really are. Yeah. I don't know where else you're going to have them for the monster gun shows. Tim, as long as I got you here, have there been any changes in the law regarding firearms and 5150 category people?
Yes, actually, that's an interesting question. Federal law, we talked about setting the floor. As most people are aware, the Brady bill requires that anyone who's been adjudicated a mental defective, that's a quote right from the law, is prohibited for life from owning or possessing a firearm. California law goes a little bit further, and that is someone who was not adjudicated what we typically call the 5150, the 72-hour hold. Those folks have a 5-year ban from possessing or owning a firearm. And that's been the law for quite some time. We have kept records where law enforcement could call in and find out if someone or a dealer could call in and find out if someone was prohibited from purchasing a firearm because they were a 5150. That law, where we kept those records, was on the books since 1991. There was a lawsuit, a pretty decent lawsuit, in which a court ruling came out and said, well, there is insufficient due process to allow a 5150 to be prohibited from owning a firearm. And this recent legislation addressed that issue and gave more due process to those individuals who just had the 72-hour hold. So now they're entitled to a hearing before a superior court to decide whether or not they can, in fact, handle a weapon safely.
So the burden of proof is now shifted to the state or the agency to prove that they should not.
That's correct. That's absolutely correct.
That's actually about a 180 from the way it used to be, right?
Well, there's still a prohibition. I mean, if you've been declared by a doctor or a medical facility to be a danger to yourself or a danger to others, you probably shouldn't have a firearm. So there's a prohibition, but if you can demonstrate that maybe the doctor acted arbitrarily and capriciously. That's kind of what happened in the Diacamos case, the lawsuit I talked about. A woman got in an argument with a doctor, and he stuck it to her and said, hey, you know what, you're a 5150. The hospital released this woman within hours, which is obviously unusual, and then she tried to buy a gun from a friend of hers, and that's where we find ourselves now. But yes, there is a hearing process. The law has changed. The burden of proof is by a preponderance, and the burden is on the people, the DA's office.
Dale, we're getting very close to the end now. Let me ask you, if the handgun's not registered with DOJ, does that circumstance constitute PC for a felony arrest?
Under the carrying concealed weapons law, generally speaking, let's take a scenario: an officer stops someone, they're carrying a concealed weapon. The weapon is not registered in DOJ. Our advice is to arrest on the misdemeanor committed in their presence, that is the CCW violation, take the weapon and the individual to the jail, and then check in our system to see if in fact it is or is not fully registered. If it is not, then they can take the issue up with their prosecutor to see if the prosecutor would like to enhance that and file a felony charge instead of the misdemeanor.
The theory, I guess, being that at least if nothing else, we're getting the weapon off the street and out of that person's hands.
Certainly temporarily, but for the officer is on sound ground, obviously, with the existing CCW misdemeanor that occurred. The issue becomes, would it possibly become a felony since the weapon may or may not be registered with the Department of Justice? And for that reason, they need to access the system we have and then talk to their prosecutor about filing the enhanced charge.
Tim, once registered, let me play off what you just said there. Once registered with DOJ, can assault weapons be unregistered?
Yes, they certainly can. In fact, we're going to have a process where you can send a notarized letter to our department and state that, for example, I took off the flash suppressor or the pistol grip and it's now no longer defined, doesn't fall into the definition of assault weapon under Penal Code Section 12,276.1.
Or I'm moving to Alaska or something.
Sure,
yeah.
Sure. And we actually have something similar to that now. We call it a no longer in possession letter.
Right.
That's put on file. Your name is taken off. It's unregistered, literally. So certainly you can unregister an assault rifle.
Gentlemen, thank you very much. This has been very informative. We hope this information has been helpful. I want to thank our guests for answering many of the questions about the changes in state firearms laws. And if you have any other questions regarding these issues, the California Department of Justice has an information line that's staffed during regular business hours. The number to call there is area code 916-227-3703. Finally, Post and the DOJ are committed to providing training on these important new issues. Should you need training beyond what may have already been provided, please contact your Post area consultant. For the Commission on Post and the California Department of Justice, I'm Doug Curley, and thank you for being with us.